Hello everyone, welcome back. This is Komal Parveen and you are watching Ace the Case. This video has been divided into two parts. Part 1 covers what is bail, types of bail and the provisions regarding the bail. So let's begin. The term bail is originated from an old French word bailer, which means to give or to deliver. Bail means the accused is set free from a jail against a kind of security which is given by the accused to the court that he will attend the proceedings in the court against the accusations made upon him, and it includes personal bond and bail bond. Bail is a mechanism used to ensure that the accused is present before the court and is available for the trial. Section 436 to Section 439 of CRPC deals with the concept of bail. So there are three types of bail: regular bail, anticipatory bail, and interim bail. Regular bail. When a person commits a cognizable and non-bailable offence, these are the offences which are so grave that a police officer can arrest the accused without a warrant or start the investigation without the permission of the court. The police can take him under the custody, and after the custody period expires, he must be sent to the jail. Section 437 and Section 439 of CRPC gives the accused the right to be released from such custody. So a regular bail is basically the release of an accused from the custody to ensure his presence at the trial. Interim bail. This bail is granted as a temporary means. This is granted for a short period of time, either during the time of pendency of an application or when the application of anticipatory or regular bail is pending before the court. Interim bail is always conditional and can be extended, but if it expires before the accused has been granted on anticipatory bail or regular bail, and if he fails to pay the amount required for the continuing the bail, then he loses his right of freedom and will be taken back under custody. Anticipatory bail. This is a self-defining. It is type of bail which is given to someone who is in anticipation of getting arrested for a non-bailable offence by the police. This is very essential bail in recent times because business rivals and other influential people often try to frame their opponents in false cases. This is also called advance bail, mentioned under Section 438 of the Act. A person who has been granted an anticipatory bail cannot be arrested by the police. While granting the bail, the court may impose certain conditions in interest of justice to ensure that no obstructions can be created on path of justice. Let's talk about bail under Section 436, which means in what cases bail is to be taken. Subsection 1 applies to the person who are accused of committing a bailable offence. Section 50 clause 2 makes it obligatory for a police officer arresting such a person without a warrant to inform him for his right to be released on bail. The presence of the word shall here denotes that it is mandatory that this person is let out on bail. It is required that a person taking bail shall bring two persons as sureties and pay an amount as a bond. It is done to ensure such person's appearance in the court during his or her trial. If a person is unable to pay the specified amount of money or bring their sureties, his bail will not be rejected. These persons will be termed as indigent persons or poor persons because they are unable to give bail within a week of his arrest. The word appear in this section also includes a person who has voluntarily produced herself before the court or police when no warrant or summons were issued. In a case Motiram versus State of MP, it was held that the right to be released on bail under Section 436 clause 1 cannot be nullified indirectly by fixing too high amount of bond or bail bond to be furnished by the person seeking release. There are few case laws. In Dharmu Naik versus Ravindranath Acharya, it was held that the refusal to grant bail in a contraventions of this section will make the detention illegal, and the police officer causing such detention may be held guilty of lawful confinement under Section 342 of IPC. Another case of State of Rajasthan versus Balchand. It was held that the provisions of the bail restored the liberty of arrested persons without jeopardize the object of arrest. Therefore, the general rule of bail is not the jail. So, subsection 2 of section 436, according to this subsection, if a person does not comply with the conditions of the bail bond, the court can rearrest such persons or issue a summon on warrant. The word here condition means if someone is unable to pay the bail amount or come for his trial in the court. In a case Muhammad Shabuddin versus State of Bihar, it was held that under no circumstances should the person be detained beyond the maximum period stated for the offence except when the delay is caused by the accused person itself. In 2005 amendment, new section was inserted 436A, which means maximum period for which an under trial can be detained. This section allows a person to be released on his surety if he has already spent half the minimum sentence period for alleged crime in the jail. If someone has got punishment of 3 years, after completion of his 1.5 years, he can apply for bail. However, this does not apply if death is punished and specified for the offence. With this, I end up with my part 1. Stay tuned. Thank you so much for watching. Don't forget to like, share, comment. Till then, bye bye.